Realtors are obligated to follow the code and are subject to discipline if found in violation. One of the important functions of the Arizona Association of Realtors AAR, is to ensure due process in Code of Ethics enforcement. The National Association of Realtors NAR, Code of Ethics and Arbitration Manual, CAM, sets forth the rules and procedures related to ethics complaints. The CAM may be purchased through a local Realtor association, AAR, NAR, or online. The following is a summary of the basic steps involved in an ethics hearing. Filing a complaint. An ethics complaint must be filed within 180 days after the facts constituting the matter complained of could have been known in the exercise of reasonable diligence, or 180 days after the conclusion of the transaction, whichever is later. If AAR's informal dispute resolution processes, e.g., ombudsman, mediation, etc., are requested, the 180-day filing deadline is suspended and only resumed when the informal dispute resolution procedures are concluded. The AAR ethics complaint form is available in the fillable form at the form, prompts the person filing the complaint, the complainant, to specify the allegations against the realtor, member, the respondent, by stating for each article alleged, I believe that respondent violated Article EPIAS of the NAR Code of Ethics because cow. The complainant is asked to provide a simple, concise, clearly stated narrative of the sequence of events and how those events relate to the alleged Code of Ethics violation. The complainant is also prompted to consider submitting supporting documentation and evidence such as contracts, agreements, correspondence, or other papers, and to indicate which allegation the documentation relates to. More detailed information on filing a complaint is set forth in the CAM, Part 4, Section 20. Grievance Committee Review. Every ethics complaint is reviewed at one of the Grievance Committee's, GVC, monthly meetings. In reviewing an ethics complaint, the GVC considers whether the complaint is acceptable in form. All necessary parties are named. The complaint was filed within the 180-day deadline. The party named is a realtor, R, and was a realtor, R, at the time of the alleged offense. There is other pending litigation or any government agency investigation that would warrant holding the complaint in abeyance. And the facts alleged in the complaint are true, whether it is possible that a violation of the Code of Ethics occurred. CM Part 3, Section 19. If the GVC determines that the named party's alleged conduct may be the basis for a violation, but that an inappropriate article has been cited, the GVC may amend the complaint by adding or deleting any article as. See CEM Part 4, Section 20D. After the GVC review of the complaint, the committee makes the determination to either dismiss the complaint as unworthy of further consideration, refer the complaint back to the complainant for further information or arbitration rather than disciplinary action, or refer the complaint to the Professional Standards Committee for a hearing by an ethics hearing panel. If the GVC dismisses or amends the complainant may appeal the dismissal within 20 days. CM Part 4, Section 20D. Response. If the GVC refers the complaint to the Professional Standards Committee for a hearing, the complaint will be sent to the respondent together with a response form that will, again, advise the respondent of the complaint. AAR generally forwards a copy to the respondent before the complaint is reviewed by the GVC. Ask the respondent to affirm that the respondent has not been found in violation of the Code of Ethics within the past three years, and give the respondent an opportunity to waive the hearing by acknowledging the conduct alleged in the complaint and by agreeing to accept discipline. CM Part 4, Section 20J. If the respondent does not waive the right to a hearing, the respondent must respond within 20 days from receipt of the complaint. SEM. Part 4, Section 21A. AAR's notice. To respondent and reply form asks the respondent to admit or deny each of the allegations in the complaint. The reply form is similar to the complaint form in that it prompts the respondent to provide a narrative of events in the order in which they happened, including all important dates, references to any relevant supporting documents, and identify any witnesses. The realtor, principals of the parties also receive copies of the complaint and the response, whether named as a party or not. Preparing for the hearing. The parties are responsible for producing the witnesses and evidence they intend to present to the hearing panel. The evidence may include affidavits, written statements, contracts, correspondence, and any other documents. The hearing panel may require that statements or any other documentation be verified by affidavits. The witnesses may include any person who can testify in support of a party's position. A realtor who refuses to testify when called as a witness can be charged with a violation of Article 14, CEM, Section 3. The parties are also entitled to be represented by legal counsel or by a realtor, or both. The role of counsel, whether legal or realtor, includes making opening and closing statements, examining and cross-examining witnesses, and introducing all admissible relevant evidence. All witnesses, evidence, and the notice of the intention to have counsel representation at the hearing must be submitted to AAR and all other parties at least 15 days prior to the hearing. CEAM, Part 1, Sections 3 and 5. The failure to provide the proper notice may result in the exclusion of the witness or evidence or postponement of the hearing. Hearing procedures. AAR will send each of the parties a list of Professional Standards Committee members, and the parties may challenge any member that the party believes could not render an impartial, unbiased, and knowledgeable decision. AAR will appoint three or more unchallenged members for a hearing panel and select one of the panel members to serve as chairperson. Thereafter, AAR will send an official notice of hearing at least 21 days before the hearing date that will include the names of the hearing panel members. CEM, Part 1, Section 7, B. The hearing will involve the hearing panel, a court reporter, and an AAR Professional Standards Administrator. The realtor, principal, also has the right to be present during the hearing, but may only act as counsel or testify if properly noticed. The parties and all witnesses will be sworn in by the hearing panel chairperson. Thereafter, the witnesses will be dismissed until called back in for their testimony and cross-examination. During the hearing, both parties have the right to present witnesses, submit evidence pertinent to the case, and to cross-examine witnesses. CEAM Part 1, Section 6. The complainant has the first opportunity to present evidence and any witnesses. The respondent will be allowed to question the complainant and witnesses. Once the respondent has asked questions of the complainant and any witnesses, the panel members may ask questions. Thereafter, the respondent will have an opportunity to state the respondent's case in the same manner as the complainant. The complainant will also be given the opportunity to question the respondent and witnesses, followed by questions from the panel members. Once questioning of the respondent is complete, both parties will be given the opportunity to make closing statements. CAM, Part 5, Chairperson's Procedural Guide, Conduct of an Ethics Hearing. Decision and final action. After the hearing is adjourned, the hearing panel remains in executive session to make a decision by a simple majority vote. CM, Part 6, Specimen Form, UE 11. The decision will contain findings of fact and a statement of the disciplinary action recommended, if any. The disciplinary guidelines are set forth in detail in Appendix 7 to Part 4 of the CM. AAR will send the decision to all parties. Within 20 days after the decision has been sent, either party may petition the hearing panel for a rehearing if, but only if, there is newly discovered material evidence which could not, with reasonable diligence, have been discovered and produced at the original hearing. CAM, Part 4, Section 22, CD. A petition for rehearing not granted by the hearing panel within 2 weeks of its filing is automatically deemed denied. Within 20 days after the hearing panel's final decision has been sent, if no petition for rehearing has been filed, or after the hearing panel's final decision subsequent to a rehearing, or within 10 days after the denial of a petition for rehearing, the complainant or the respondent may file an appeal. SAM, Part 4, Section 23. The only basis for an appeal is misapplication or misinterpretation of an article, says, of the Code of Ethics, procedural deficiency or any lack of procedural due process, or the discipline recommended by the hearing panel. At an appeal hearing, the hearing panel chair will present a summary of the case, and each party has an opportunity to present reasons why the hearing panel's decision should be upheld or reversed. The appeal panel may decide to adopt or modify the decision, dismiss the matter if it concludes the findings of fact do not support the decision, refer the decision back for a new hearing, or impose alternative discipline or refer the decision back to the original hearing panel to reconsider the discipline. The appeal panel's decision is final. If the decision is not appealed, the AAR Executive Committee will adopt the decision, unless it is concerned with a possible procedural deficiency, in which case the case will be referred for a new hearing, is concerned with the appropriateness of the sanction, in which case it may impose alternative discipline or refer the decision back to the original hearing panel for further consideration, or concludes the findings of fact do not support a possible violation of the Code of Ethics, in which case the complaint will be dismissed. The names of members who have been found in violation of the Code of Ethics twice within 3 years will be published in an official communication vehicle of the association in which the violator holds or held membership. AAR General Counsel Michelle Lind is a State Bar of Arizona board-certified real estate specialist and the author of Arizona Real Estate, a professional's guide to law and practice. This article is of a general nature and may not be updated or revised for accuracy as statutory, case law, or policy changes following the date of first publication. Further, this article reflects only the opinion of the author, is not intended as definitive legal advice, and you should not act upon it without seeking independent legal counsel.